everyone, welcome back to my lecture series on Hindu law. This is the second video on Hindu law. In the first video, we discussed about introduction to Hindu law, and in this video, our focus is on source of Hindu law. In the first video, we discussed the basic concepts of Hindu and what is Dharma and importance of Dharma Shastras on legislation, to whom all this Hindu law is applicable, and what are the enacted laws for Hindus in India. These all are covered in the first video, and in this video, our focus is on to know more about sources of Hindu law. And the entire video series of Hindu law is based on the book titled Hindu Law, written by Dr. Rakesh Ainapur, which is available on Amazon, Flipkart, and Vision Bookstore. You can also download ebooks from Google Play Store and then Amazon Kindle. With this brief background, let's start focusing on our today's subject matter, sources of Hindu law. Today's subject matter is sources of Hindu law. Generally, sources refers to the basis from which law evolves. Okay, what are the different sources which legislature team considered while preparing a Hindu law? Let's go through that one by one. We know that Hindu laws have taken a lot of inspiration from ancient traditions and ancient scriptures of Hindus. Further, it is also based on a modern legal principles which are evolved in the Western countries. So the entire Hindu law is based on two sets of sources. One is ancient sources, which is based on our Hindu scriptures, and the second one is based on a modern sources. We will go through one by one in this detail. This is almost a history of 6,000 plus years where various Hindu scriptures were considered while developing Hindu laws. Okay, and we all know that Dharma is a very crucial concept in Hinduism, because Dharma is all about doing right things, and it is a duty of every person. It is an ethical duty. So this is a major pillar for Hindu law, which is part of our ancient sources. So ancient sources are further, we can classify into four subcategories. Shrutis, second one is Smritis, third one is Commentaries, and the fourth one is Custom. And modern sources are Equity, Justice and Good Conscience, Precedents, and Legislation. Okay, these are the two major sets, ancient sources and modern sources. Let's go one by one. Let's start our discussion with Shrutis. Shruti is part of our ancient sources. Shruti is all about knowledge or the act of knowing. This is an ancient source for Hindu law, which is originated from 400 to 10,000 BC. What actually Shruti means is, it is where God has directed, or God has given his preachings to the ancient sages. This is believed that God has, our sages spoken to God directly, and they created the book. Okay, so the books are popularly known as Vedas. There are four Vedas in Hindu history. So Rig Veda, Yajur Veda, Sama Veda, and then Atharvana Veda. So these are the four Vedas which are written based on the God's wordings, which are heard by our ancient sages. So the first one is Rig Veda, which focuses on hymns and praises of deities, reflecting spiritual insights. Okay, and the second one is Yajur Veda. It is all about rituals and ceremonies which are practiced by Hindus regularly. Sama Veda is all about melodies and chants. It is all about a music for a spiritual expression. And the last one, Atharvana Veda, is all about addressing various aspects of the life, like legal and ethical consideration. This is how Vedas are classified in four parts, like Rig Veda, Yajur Veda, Sama Veda, and Atharvana Veda. Sorry, not parts. Like, these are four important Vedas which covers various aspects of a human being, life of a human being. So moving on. Each of these Vedas are divided into three parts. First part is a hymns or a Samhita. Second part is Brahmana, where the duties and performances were explained. And the third one is Upanishads, which talks about fundamental essence of the duties, why these duties need to be performed. So this is how each of the Vedas are structured. And that's all about Shrutis. Shrutis are about knowledge, which is given by God directly to the rishis and evolved between 400,000 to 10,000 BC. Most important Shrutis are four Vedas: Rig Veda, Yajur Veda, Sama Veda, and Atharvana Veda. Each of these Vedas divided into three parts: Samhita, which is nothing but hymns; the Brahmana, which is talks about duties and performance; and Upanishads talk about fundamental essence of these duties. With this, let's move to a next one: Smritis. Smritis is a Smriti. The term itself shows that remembered. It is these are the words which God has given to sages, from sages to other who heard and remembered those knowledge. So it was in the minds of a few scholars, and they have written it. Okay. So Smritis are divided into two parts: early Smritis, which are called as Dharma Sutras, and then later Smritis, which are called as Dharma Shastras. Okay, these early Smritis were between 800 to 200 BC, and the later Smritis started from post 200 BC. Dharma Sutras major scholars include Gautama, Bodhayana, Apastamba, Vasista, Vishnu, and Harita. Dharma Shastras scholars include Manu, Narada, and Yajnavalkya. These are the three major Smritis which people are going through in recent times also. So a lot of texts available on these three Smritis. Okay, this is about two Smritis, two sets of Smritis, and but the subject matter of these Smritis are two major aspects. Like one is Achara and Vyavahara. This is nothing but a normal code of conduct and behavioral norms, how people should live in a society, what are his duties and responsibilities. And the next one is a Prayaschitta. Prayaschitta is all about if any person does a wrongful action, then uh, uh, what is the action needs to be taken. That is all about Prayaschitta. So this is the subject matter of all the Smritis. One of the most popular or most talked about Smriti is a Manusmriti. So I'm not going to discuss about each of these scholars' contribution, because that may not be relevant to know. Then it will become a more of a Veda classes rather than Hindula. So just a brief note on Manusmriti, which gives that how Smritis are structured. Okay, Manusmriti is written around 200 BC. It is one of the oldest Smriti in the latest part of the world. It encompasses almost around 18 titles. It talks about how debts should be managed, pledges, sales, deposits, partnership, gift, wages, agreement, boundaries, disputes, master and servant relationship, husband and wife dynamics, partition and inheritance law, betting and gambling regulations, assault, defamation, theft, robbery, and adultery. We feel that these are part of our modern laws, but no, it was there during early ages also, and these were clearly covered as part of Dharma Shastra in Manusmriti. So these are the 18 titles which were covered part of Manusmriti, and Manusmriti had 1258 verses and 2694 slokas, covering the entire ethical, social, and legal aspects for a human life. So it is an invaluable source for understanding the ancient Hindu legal system. Okay, so this is all about Manusmriti, but more or less other Smritis also talks about one or two key areas of the human life. So I'm stopping our discussion on Smriti at this point. Let's move on next source, which is a digest and commentaries. Smritis were little difficult to understand because those were written in shlokas and hymns. So there comes to simplify that during 700 AD to 1700 AD, various Hindu scholars tried to simplify whatever is enshrined in Smritis, and those are called as digest and commentaries. This is same way that the way we have I have gone through all the Hindu laws and I am simplifying it. In the same way, whatever was written by Smriti Karas, that was gone through by uh, various scholars in 780 to 1700 AD, and they have taken the Smritis as a base and they have given their commentaries to make that common man can understand those Smritis. So Manu Bhashya given by Medati. So this is a commentary on Manusmriti, which talks about whatever is part of a Manusmriti that was simplifiedly written by uh, Medati. Then Manabhatta, it is again talks about uh, all simplifying the legal complexities in all the Smritis. The most important one is a Mitakshara by Vigneshwara Bhatta. This one talks about inheritance, loss of inheritance. And the other important counterpart of this is Dayabhaga, Jimuta Vahana. This also talks about inheritances. The Dayabhaga by Jimuta Vahana is being popularly followed in Bengal. In the rest of India, Mitakshara inheritance, law of inheritance is being followed. Apart from that, we have other Smritikaras, other digestive and commentaries, Aparaditya, then Smriti Chandrika by Devam Bhatta, Vikra, Viramitrudaya from Mitra Mishra. So these all are various other commentaries. So commentaries are nothing but a simplified version for us of a Smriti for a easy understanding by common people. Okay. Next is customs. So we saw that Shruti, then Smriti, and then Shruti, Smriti, and commentaries and digests. These all are the written forms of law. Some way the rishis have taken Gan from gods, and then we have a Smritis, which was written by scholars with their remembrance, and then to simplify the Smritis, we have a uh, commentaries and digests. But the most important source of Hindu law today is customs. Okay, custom is a major important source for our Hindu laws. In one of the leading case, it is Supreme Court is also clearly said that Maura versus Ramalinga Setupati, customs always holds good over a law. Whatever people are following, as long as it is a moral, as long as it is a reasonable, as long as it is continuously followed by a people, then these are like a unwritten laws. Customs are unwritten laws. Okay. Customs are very, very important. It is a customs is nothing but a achara or a practice which people are following for a long time. Okay, there is a practice in some families, or there will be some practices within a community, or it is in within a state, or within across India. So there are various customs and practices which are being followed by Hindus based on their tradition, their experience. So customs become a valid laws in India, but provided there should be continuous practice by the people, there should be some amount of reasonableness and then moral. Okay, as long as it is not affecting the law, killing someone is a practice, then it is not allowed. But at the same time, marrying maternal uncle's daughter is a valid practice in southern part of India. So like that, so certain practices and other things are allowed even though the law prohibits those things. Okay. So this is all about customs. Customs can be a local customs, which is followed by individuals or in a particular region and other things. Family customs, which is particularly followed by one family, otherwise complete caste or a community customs, which is followed by that particular group of people who belongs to one community, they follow it. In the eyes of law, community customs are more prominent because the family customs can be misstated and then like so it may create a nuisance, but community customs are considered as widely accepted in Hindu Hindu laws. So, what are the characteristics of customs which, okay, if it is accepted by Allah, if it is ancient in nature, very old, and there should be a continuity of practice. Everyone should keep following it from a longer period. It is not only ancient, but they should follow it. Then only it will be called as customs. Then it should be reasonable. So means it is a rational, like it should not be something unreasonable. Okay. It is not, it should not be against public policy. That's what I told. If at all I want to go and kill, it is as part of my custom and I'm going to kill it. So this is not a reasonableness. Okay. So as long as it is a reasonable, it is accepted. Again, moral grounds. It should be ethical also, and it should be in consistency with statutory law. See, laws are defined already. It should be relatively consistent with the statutory law. It should not be as same as that, but there should be relatively consistent with the statutory law. Uniformity. This practice should be uniform. Like you are doing it is from beginning, you are continuously practicing it. You should practice in the same way. Small variations are okay because of time passage, but the uniformity is also required. Certainty and clarity. So there should be a clear clarity on that what they are practicing, and people, public of that community should accept it. And we already discussed that it is a antiquity, like it is a very very old thing. Okay, these all are major characteristics. And as I said in the earlier slide, in the case of Maura versus Ramalinga Setupati, court is clearly said that custom is a major source for Hindu laws and it should be considered beyond the statutory laws. Okay, whatever people are following, as long as it is reasonable and inconsistent with the moral grounding and inconsistent with the statutory law, these are considered as law itself, unwritten laws. Moving on to a modern sources, I don't spend much time here. Modern sources is all based on a Western principle and English law. So equity, justice, and good conscience. So any decisions, right? It is very difficult. Sorry, any law. It is very difficult to cover all the aspects. Certain 80, 70, 80% of the human life can be covered as part of a law, but changing needs we cannot cover it. So in that case, if law is silent about certain facts or a certain aspects of human life, then that should be considered considering the equity, justice, and good conscience. So if law is silent, then we have to consider equity, justice, and good conscience. It is not only an English law, but even in Gautama also said that if law is anything is silent on certain aspects, so in that case he said at least it should be at least it should be answered by discussed with the 10 intellectuals in the family society, and based on their consensus the decision should be taken. At the same time, Yagnavalka also said it should be based on a nyaya, okay, reflecting a natural equity and justice. So Yagnavalka, so in ancient Hindu scripture also it was mentioned, and English laws are also based on this principle. So Supreme Court consistently says that they applied equity, justice, and good conscience when laws are not clear and which are not giving a clear direction. In those cases, equity, justice, and good conscience should be used. Then precedents. Precedents are nothing but a judge-made laws. Whatever uh, judgments given by judges will holds good. Okay, so if a law is silent, if law is not clear to people, then the judgment given by the judges in the earlier cases of a similar nature will holds good. How? There is a hierarchy for it. The lower court should follow higher court decision. Like for district court, will take care of high court decisions. If high court gives some decision on a particular matter, that will be bound by all the district courts under it. And if Supreme Court gives it, then all high courts are bound by this. Same way, if High Court in Karnataka and High Court in Andhra Pradesh have given different decisions, then they are not bound by each other. So only the precedents given by higher court should be followed by the lower court. Otherwise, if it is a parallel level court, then it is not bound by other courts to follow it. So precedents are judge-made laws, the decisions given by judge in the previous cases similar in nature that will be considered. Many a times these precedents will be considered as incorporating in a rules and making amendments in a existing laws. Clear, guys? The second source of modern law, second modern source is precedents, justice or judgments given by law. So these are called as judge-made laws. The final one, legislation. Legislation is laws which are established, like which are enacted by a government or legislators. Okay, there were many legislations were there in India before enacting major Hindu laws in 1955 and 1956. The four Hindu laws, whatever we discussed in the first video: Hindu Marriage Act, Succession Act, Adoption Act, Adoption and Maintenance Act, Inheritance and Succession, Marriage. All these acts, before enacting this, there were various laws were there in India. uh, Hindu Widow Remarriage Act, Hindu Transfer Bequest Act, Child Marriage Act, Arya Marriage Validation Act, Hindu Marriage Validity Act. All those things were there before this 1955-56 Act. So these acts were also considered while preparing acts in 1955 and 1956. Okay, so legislations, whatever earlier made, was considered as a source and then drafted a new set of four laws. So this is all about the sources of Hindu law. Just quick recap: we have two major sources, ancient and modern. In case of ancient, it is Shruti, nothing but Vedas, Smriti, which is a remembrance by scholars and they have written it. Then we have commentaries and digests written by scholars to simplify Smriti. And the fourth important one is customs. Okay, these all are ancient sources. In the modern sources, we have justice, equity, justice, and good conscience, and judgment. Finally, legislation. That's all, guys, on sources of Hindu law. In the next video, we will go through schools of Hindu law, Mitakshara and Dayabhaga. Thank you so much for your time. I request you to like my video, subscribe it, and then share it with your friends. That will keep motivating me to add, upload more and more videos on Hindu law. And I also love to hear feedback from you guys. If I have stated something wrong here, please let me know. I will correct it and then re-upload it. Thank you so much, guys.